Appeals Division 1 is now in session.
You may be seated. All right, we are now here for oral argument in CV230611, Anderson versus State Farm. Again, as I mentioned in our first argument, we record and live stream these proceedings. So if you could again announce yourselves and your client's name. You have a maximum of 20 minutes per side, and you're not required to use all of your time. Again, if you'd like to reserve time for rebuttal, please go ahead and do so. We conferenced this case this morning, so we're up to speed on the substance of your briefs and the record as well. Counsel, you may proceed.
Good morning, Your Honors. I am Tyler Abrahams on behalf of Defendant State Farm. The central legal question in this appeal is the same as in the prior case, and that question is who has the authority between the insurers and the appraisers to make the final determination about causation in an appraisal setting. The trial court concluded that it was the appraisers. The court reasoned that as soon as State Farm said there was coverage for 6 tiles, it forfeited the right to contest coverage or causation about the other 994. Say there's 1,000 tiles on this roof. We accepted 6. You forfeited the right to determine the causation for the other 994. You've given that over to the appraisal panel. That's contrary to the policy. It's contrary to Arizona law, and as I'd like to take you through, it's also contrary to a lot of practical considerations. In the balance between the appraisers having the final authority and the insurers having the final authority, there are many practical considerations and safeguards that benefit the parties when the insurers have that final authority instead of the appraisers.
The contract language in this case is different than the one we just argued a little bit.
Yes.
Does that matter?
It doesn't matter here. The effect is the same. The verbiage is different, I admit.
Well, and a notable difference is this one doesn't say that the appraisers can't determine questions of causation.
It doesn't have that. It doesn't have that sentence, but it achieves it by embedding the word causation throughout the entire policy. One can't look at this policy and not stumble on the word causation in every section. Caused. Is it caused by...
Well, the only section we care about is appraisal.
That's not true. The appraisal section refers to anything else. It says appraisers can only look at the amount of loss, and it expressly forbids the appraisers. The policy does. The policy forbids the appraisers from considering any other question of interpreting this policy, any other fact, any other question of law. That's in the appraisal provision, so it refers out to the rest of the policy as well.
It says any question of fact, question of law, and I'm excluding the numbers that are there, question of coverage, other contractual issues, or to conduct appraisal on a class-wide basis.
Correct. That's referring to the rest of the contract. You can't read it apart from the contract. It's not a silo unto itself.
Is question of coverage synonymous with question of causation?
Not always, but question of causation is...
How could you have a covered event that wasn't subsumed into causation?
You can have a matter that's denied, but not on causation grounds. There are grounds to deny claims that aren't causation related.
Yes, this is caused by a covered event, but you didn't timely submit it, so therefore it's not covered.
It happened outside the policy period. You haven't presented enough evidence. You haven't gone through the procedures, the conditions to submit a claim. There are reasons that aren't causation related to deny coverage, but we're all here today because of causation-based reasons. And it's embedded through the policy. IR 10 highlights the instances where cause is relied upon in the policy. Those are highlighted in yellow. The trial court made no assessment of the policy, though. It may have considered it. I don't know what was in the judge's head, but there was no analysis in the order. It, for all intents and purposes, ignored it as far as the eye can see. That's problematic. It also is contrary to Hansen, which is the bedrock case, the bedrock reported case in Arizona. Hansen has 2 principles. Appraisers are bound by the submission agreement, and they cannot consider issues of causation, issues of coverage, excuse me. The trial court's order violated both those principles by disregarding the verbiage.
But if the policy allowed it, they could determine issues of coverage. I mean, if you guys could contractually agree that appraisal could cover.
I suppose that's true, but it violates the principle of appraisal, which is to let the parties narrow the issues regarding the amount of loss while reserving the rights inherent in the policy to the insurer. That's the balance that Arrowhead struck. We're trying to find the balance here. A disconnect that I understand the court might have is what happens in certain circumstances. I want to walk you through a few of them. If there's 1,000 shingles, and State Farm said, yes, there's coverage for all 1,000 damaged shingles, but we're only going to, tiles, we're only going to pay $1 a tile, and they're asking for $2 a tile, that's an appraisable question. That matter gets appraised every day. The appraisers confer and they say, you know what, the market price is $1.75 a tile. That's what the award is. $1.75 times 1,000, do the math, and there's the award. It gets confirmed, it gets paid, it's done. It never sees the light of day because there's no contest. That's an agreed upon coverage question. In other instances, the homeowner comes in and says...
Wait, you said that's an agreed upon coverage question.
Yeah, there's no coverage question at all. Coverage is agreed.
Okay.
There's a situation...
Well, that's the case here, right?
Not quite. Let me get there in just one moment, Your Honor. In other instances, there's 1,000 tiles demanded, and the insurer says, I'm not going to cover any of this for whatever reason. That issue rarely gets appraised because there's no coverage, there's not really an interest in appraising that. We can talk about that, but that's a corner case. The point being, that's not often before you all. Commonly, what is disputed in legal circles is the partial denial. State Farm says yes to 6. They want the rest of the 1,000. What happens in that situation? That's where the rubber hits the road, where that's the dispute, and that's where things get out of whack. There is every incentive by the insurer to be accurate about what is and isn't covered. They have the incentive to say what is not covered because they don't pay for it. They have incentive to say what is covered. That's the duty of good faith and fair dealing. They don't have that incentive. Their incentive is to ask for as much as possible. 1,000. What's the consequence? 10,000. What's the consequence? They don't have a consequence. And so they try to shove it into this process, this appraisal process, which we now see is an unappealable finding of theirs about causation. We start to see some of the imbalances. I want to address some of those imbalances here. Imagine a world where the insurance company gets final say on causation. You're very familiar with this world. It's the world of the duties of good faith and fair dealing, protecting them. We say it's 6 tiles, and we get to say 6. Let's say that the appraisers only looked at 6 tiles, and they wrote that award, and they're not satisfied with that. They get the right to appeal to court. And when they appeal it, they get all kinds of benefits. They get experts whom they hire. They get Daubert proceedings to protect against junk opinions from those experts. They have professional advocates coming in to present their causation evidence.
Wait, these are benefits? That they have to go hire experts on their own dime?
Well, it is a benefit. It's a benefit once you see the contrasting side. Because on the other side, if causation is determined by appraisers in appraisal, State Farm the insurers get no right to appeal. They get no protections against junk opinions. They get no professional advocates advocating their position in front of legal professionals who understand evidence that is relevant should only be considered. Evidence that is material should only be considered. Evidence with foundation should only be considered. None of that happens in an appraisal. It is invisible. There is no transparency in an appraisal process.
Well, then why would you include that in your contracts?
We include it as a contract because it's a provision that is required. It is a provision that has been...
It's required?
It's a provision that's been around for a long time.
Okay, but it's not required. I'm sorry. I appreciate your arguments, but I refuse to believe that State Farm is including an appraisal provision to its detriment in every contract when they're not required to do so. So I assume that there's equal, at least, I'm not saying that it's an adhesion contract like we heard in the previous argument, but there's at least an equal benefit to State Farm as they anticipate giving to the insured. So if you want to keep wasting time on this argument, you can, but I would suggest you move on.
Very well.
And actually, Counsel, I have a question about your first scenario you presented. So both parties agree that 6 tiles were damaged, but disagree on whether they should, or they're worth $1, or the replacement cost is $1 or $2, so you send that to the appraisal panel. In that case, would you submit some sort of submission agreement to the appraisal panel saying that you both agree that these tiles should be covered? It's solely just the amount of money.
It's not done through a separate agreement. The submission agreement is the policy and the conduct of the parties in submitting to appraisal. I agree. It's typically done through letters, and in this case, it was done through letters by the policyholder saying, we request 1,000 tiles, and State Farm saying, well, we're not agreeing to 1,000, we're only agreeing to 6. Here's our estimate showing 6. Those documents are delivered to the appraisers and with instructions saying, here's our appraisal provision.
Your colleague cited to IR10 Exhibit J in the previous case. Is there a specific cite to the record on this case?
Regarding what the appraisal provision is, or regarding what the letter reserving our rights?
Submission letter.
IR16 is the submission letter agreeing to submit. I would also add that page 2 of that letter is where you'll find those reservations.
Okay, thank you.
Presumably there's some sort of retention agreement between State Farm and at least its appraiser, right?
There is.
And and I would presume it lays out the scope of work.
It does. It varies
Is that
because
in the record? I'm guessing that's not in the record here, that agreement.
I don't know if it is. I don't believe it is in this record. They are.
So, I'm sorry, go ahead. You answer his question. I apologize.
I've answered his question. Judge Morse, go ahead.
Okay. In the letter you're referring to, it says in page 2, we will agree to submit this matter to the appraisal process to resolve the differences in the amount of loss. However, we are only in agreement to appraise the damaged items for which we have admitted liabilities outlined in the enclosed estimate. That's what you're referring to?
Yes, Your Honor, that's 6. The next paragraph at the bottom also says, with respect to any repair or replacement of property that falls outside the scope for which we have admitted liability as outlined by our enclosed estimate, we reserve our right to exclude those costs from any appraisal award or payment based on the award. The appraisal provision gives them that right too.
Same questions we were asking your colleague in the previous case. Who committed the error in this case?
There's 2 errors in this case. The first is the trial court granting the appraisers an authority that they didn't have. The second error is in the appraisal panel. They did half their job. Their job, as we are proposing, is the 6,700 arrowhead procedure, and that is to do it, in this case, a 2-part appraisal award. Well, you want 1,000 tiles? Here's what 1,000 would look like. They did that part of the job. You want 6 tiles? Here's what that would look like. They didn't do that part of their job. And that's where we're asking the court to, number 1, say that the trial court erred about the authority and establish the 6,700 arrowhead procedure as the procedure. It would avoid this problem altogether. It would have 2 parts. The jury would eventually weigh the causation evidence and pick from one of the 2 sides of the award. It would still give effect to the award. It would give it meaning, which is their biggest concern. It would become, their argument is always it would become meaningless. Arrowhead makes it meaningful. It just lets the jurors pick from which side of the ledger they think is based on the causation evidence that's presented to them.
So State Farm gets an advantage out of that.
How's the advantage?
Because they know at the outset of litigation what their potential loss would be. They are able to then decide, do we want to settle this, or do we want to go ahead and litigate between this $160 and $5,000 difference?
But that's good. That's the purpose of appraisal is
to State Farm.
No,
I'm going back to the previous argument that you were making, but
I disagree with you in that I think it is a neutral benefit to the parties to narrow the issues and increase the chances of settlement.
Foreseeability is not a benefit to State Farm, knowing they're outlining the potential losses that they might suffer.
Okay, I agree that is a benefit, but they get a benefit as well as far as increasing the odds of settlement.
Right.
Yeah, I don't. When he says advantage, I don't think he's saying unfair advantage. He's just saying there's a benefit to the parties.
I agree. I mean, I think there is a benefit to the parties in this process.
Does this appraisal award separately list out the amount of damage for the 6 tiles?
No, it doesn't, and that's where it erred. It's also a different process,
so
right?
The jury is looking at this and wants to decide between 2 numbers. It only has 1 number.
That's the error.
So you want to redo the appraisal?
No, they don't need to look at anything else. They have all the information they need. They just need to write a different piece of paper. And that's why we didn't move to confirm it, That's also
By
a
they, you mean appraisal panel.
the appraisal panel just needs to author a different award. They don't need to inspect anything. They don't need to deliberate again other than just to say, here is what, we've already written what 1,000 tiles would cost to fix. Now we need to write what 6 tiles would cost to fix on one document.
In this case, you guys agree there was a covered loss, but your argument is that that covered event only damaged 6 tiles, right?
Yes.
Okay. Now, the appraisals went out there and they said, well, it looks like this entire roof's been damaged.
Yes?
And we think it was damaged by this event. So are they supposed to figure out which 6 tiles were damaged by the covered event, which 6 tiles were not damaged by the covered event?
First off, I disagree with your premise. They did go out there. They said this tile has a lot of damage to it. They did not say it is damaged by the covered event. This is the factual dispute that we don't need to reach unless we...
But they said the damage occurred on, I forget the date, but whatever the date was.
Well, they said that they said that they decided it irrespective of loss causation. And I think that's important to this case because it's what we're asking, that's what the arrowhead process would be. The arrowhead process would be we abstain from anything about causation analysis. We simply adopt their findings, and here's what it would cost. We adopt their findings, here's what it would cost. It is neutral. Judge Catlett, you asked, what's a case that we should look at if I was to look at one case? It would be Arrowhead, but it would also be the California Lee opinion. That's 188 Cal Reporter 3rd, 753. It's a studious review of California's appraisal framework. It is almost an inverse mirror of this, but they arrive at the exact same place. They have the same bedrock principles as Hansen, and they decide, citing a case called Devonwood, that what I'm calling the Arrowhead procedure is their procedure, and causation is a question for the jury, never for appraisers.
I mean, when they come back and just list one amount, one way to look at it is they didn't do their job because there should have been a second amount. The other way to look at it is they decided that was the covered amount. And if they do that, how are they exceeding their authority?
They weren't authorized to decide what the covered amount is. They are only entitled to decide the amount. And when there's a dispute about what is and isn't covered, that doesn't fall to them. The insurance company doesn't forfeit the right to make that
But in
decision.
your scenario where there's 5 tiles versus 1,000, so both parties agree there's some coverage and there's some causation. So I guess my struggle is, does the 995 tile delta between those two, does that fall into the causation bucket or does that fall into the damages bucket?
If the basis for the dispute is about causation, it falls into the causation bucket.
Right, but that begs the question of whether that 995 tile delta is causation or damages when the parties have agreed there's coverage and causation.
Judge Catlett, there must be a situation where a partial denial is enforceable on a partial basis. And if by saying we are going to cover 5, you've forfeited the right to contest the 995, that's forfeiting too much under the policy. That's just not the way it can go.
So when the Superior Court said the State Farm is not entitled to go through the appraisal and pick out those items that it believes were not caused by the covered loss event, after you guys had agreed there was a covered event, in the guise of litigating the issues of coverage. That was the error?
That is a fundamental piece of the error, yes. Otherwise, what good is a partial denial is literally selecting things that they've claimed and saying yes to coverage and no to coverage. It is picking and choosing.
So if the award came back and just listed an amount for the 5 tiles, you would concede that that's an illegitimate?
Incomplete.
What if the appraisers had come back and said, these 5 tiles were damaged, but it is impossible to maybe this is such a counterfactual hypothetical, but it requires replacing the entire roof in order to repair those 5 tiles. Would that bind you at that point?
You're asking a question about repairability of the roof?
Yeah.
That's not an issue here. Repairability is a whole separate kettle of fish. It's not an issue here because these 6 tiles are all on the very edge of the roof. And
but I think it's a hypothetical.
As a hypothetical, it's different. It's not necessarily causation related. And so I would say that that's maybe given different treatment. As long as it doesn't hinge on an exclusion where the word is causation is required as part of the analysis, I think that it might get different treatment.
How do we know that's
here.
not what they decided here?
I don't know what they decided here. We know they didn't decide because they didn't consider loss causation. We know they didn't decide about repairability because that's Mr. Solin's declaration. IR 18, paragraph 10, where he says, if roof damage occurs at the edge of the roof, it can be repaired without making any further damage. Repairability isn't an issue here.
Right, but then we have a contrary declaration from their appraiser who's saying, we did decide this, and at that point you have a fact question, I guess. You have counter testimony between two experts, and the trial court made a finding, and don't we have to defer to that?
No, I believe that if there's a factual dispute, that's a basis to at least hold an evidentiary hearing to get to the bottom of it. The court didn't do that.
Did you ask for an evidentiary hearing?
I believe I did. Yes, in the reply motion, I believe I did. But the fact that there's a disagreement about what the appraisers were trying to achieve, that's not reason to confirm it. That's reason not to confirm it. I'll reserve the rest of my time.
Where do we begin? All right. Pardon me. I feel a sense of deja vu here. The policy here is a little more specific, a little narrower than that massive thing last time. At least it talks about, and this is the opening brief, pages 2 and 3 has the quoted policy language. Only you or we may demand appraisal. It's got to be in writing. And the appraisers attempt to set the amount of loss of each item in dispute, a little more specific than the last time. And then, in all instances, the written report will be itemized and state separately the actual cash value, replacement cash value, and they did that. And then it says, the written report of agreement will set the amount of loss of each item in dispute and will be binding upon you and me. We should pack up our tents and go home. It's binding on the insurance company, but the insurance company doesn't want to be bound. The appraisers came back with an award that's set out on page 17 of my answering brief. It sets out here the replacement cost value for the dwelling, the actual cost value for the dwelling. There were a number of items that they decided that they did not appraise, but for the important part, the damage to the roof, they came up with these two different figures. And that's binding on the insurance company.
But what's binding? So going back to the example we were talking about earlier, if it's, or that your colleague was talking about earlier, if it's the dispute is between a $1 and $2 value per tile, that's binding, but that doesn't necessarily determine that they have to replace those tiles, right?
But there is a dispute here. But the insurance company said we want to pay this amount for the covered loss, and the appraiser said nope. That's way low. Here's the correct amount.
Binding can mean the $2 value per tile without meaning you're bound to say it's 1,000 tiles versus 6 tiles. I mean, so binding doesn't necessarily carry all the weight in this case.
It carries a lot of weight because it says the written report of agreement will set the amount of loss of each item in dispute and will be binding upon you and me. That carries a lot of weight with it. The written agreement, the written report of agreement, you're bound by it.
Right.
And so what they said in there is what you're stuck with. So you, as the insured, you've gone through the process they force you to go through. You've got what amounts to an arbitration award. You go to the Superior Court to enforce it.
So the general principle is arbitration is a creature of contract and is only to the extent that you have a contract to provide for it.
Yes.
The parties have to agree to arbitrate.
Yes, sir. Yes.
So, and we have a contract here that says, as I read with your opponent there, any questions of fact are not, the appraisers umpire have no authority to decide questions of fact, questions of law, questions of coverage, or contractual issues, or to conduct appraisal on a class-wide basis, which isn't before us here. But
If you took that language literally, what the heck are the arbitrators doing?
well, they're deciding.
They can't decide anything. They can't decide facts. They can't decide law. They can't decide this, that, and the other.
Well, any other question of fact. So in this case, they're deciding that, in his hypothetical, the $1 versus $2 per tile.
Well, here they're deciding what is the correct amount for the replacement cost value, actual cost value. That's what they're there to do. Pardon me. Gosh, that's what they're there to do, and that's what they did. And once they did that, then you've got a right as a consumer to go into the Superior Court and say, look, I've got what is really an arbitration agreement. I have a right to enforce it under the statute. They can come in if they want to. There's a statute that says they can come in and say, don't confirm the award, but the only way they get to do that is to say the arbitrators exceeded their powers. But the arbitrators had the power to decide in their written report of agreement to set the amount of loss for each item that was in dispute.
Right, so how is the issue of 6 tiles versus 1,000 tiles, how does that go to the amount of loss?
That's a red herring, isn't it? I mean, they're deciding the amount of each item in dispute, and that's what they were there to do, and that's what they did. There's 6 tiles versus 1,000 minus 6, 994.
His argument is 6 tiles versus 1,000, and your argument is roof versus not, really, right?
Well, the argument is...
The item in dispute from your perspective is the entire roof.
Yeah, well...
Or the entire damaged
right.
portions. Okay.
What you're there to decide what the amount is supposed to be paid for this particular loss. And State Farm says, minuscule amount. Arbitrators say, no, much bigger than that. And they both agreed, and away you go. You've got the award. You get to go to the Superior Court to enforce it, exactly what they were supposed to do. And then State Farm comes back and says, no.
Mr. Evans,
can't
help
do
me
that.
understand another couple provisions in this contract. So I was reading from H earlier, subsection H of section 4, the appraisal section. J.I. says the appraisal award shall not be entered as a judgment in a court. What does that mean? And did we comply with the contract here?
My frank answer is it means nothing, because you have the right to take that appraisal award, which is an arbitration award, to the Superior Court by statute. You have the right to get it confirmed. So that clause is in
So the
conflict
judgment
with the
is
statute.
separate, it's based upon the appraisal award, but it's
Right.
not actually, okay.
Yeah.
And then another thing about the judgment that makes me confused. So the court awarded, the judgment entered an amount of $115,000, which consists of the appraisal award actual cash value less the deductible, and then awarded attorney's fees and costs. And then at the end it says, the interest shall accrue at a legal rate of the prime plus 1% for a total of 9.25% on the attorney's fees and taxable costs. Why is post-judgment interest only attributable to the attorney's fees and costs?
Should be attributable to everything.
Right.
We can straighten that out on the remand.
Okay. Well, it made me wonder if maybe the court's saying that this
But
isn't.
I thought you wanted us to affirm.
Well, you're going to remand. You're going to affirm, and then you can say, and in accordance, what's the usual language? We affirm the judgment and remand for further proceedings.
Consistent
And that would
with
be a
this
further
decision.
proceeding.
Okay.
A little bit of cleanup. Nobody's perfect, not even Caitlin Clark.
Well,
I've seen that.
I was wondering if this. She's amazing.
Isn't
Yeah,
she?
crazy.
She had a tough game yesterday, but she is so professional.
Wow.
Anyway, I'm sorry, I'm sort of a Clark fan. You know what I like about her most?
What was I
Well, anyway.
checked the stats to see what the over/under was on your Caitlin Clark references here.
Yeah.
So
Well, what I like about her most is what I like about this court. You're very professional. You don't say bad things about people. People say bad things about you. I never do. But you never return the favor.
Who's saying bad things about me?
Never. I would never do that. Never.
Anyway, so my thought was maybe there was some significance to that the court wasn't treating this as a final judgment, and so causation and coverage could still be litigated. That's
I don't think so.
No.
I think it comes in as the award. I think the court was rather emphatic about it, and it said the findings of fact as to causation are binding on the parties, and that's just a common sense. I mean, they're there to determine what the amount of the loss is.
I mean, does it have to have 54B or C language in order to be a final judgment? It can't have C language here because we have the bad faith claim hanging out there, but,
It didn't have B language in
No.
it? Ooh.
and in fact, I think the insurance company asked for it to have B language in it, and the trial court at least implicitly refused to put it in.
I think you still have jurisdiction under Section 12-2101A, because this is a special
Yeah,
order.
I'm not questioning our jurisdiction. I'm just
Thank
saying, No. I'm just saying, yeah, and there's a case I think that Judge Thumma did that said.
It's never been a typical case, but, there's a lot of these pesky little district court cases floating around. Some are favorable for us, some are not. Some are published, some are not. This really needs some guidance from this court. I mean, to straighten this mess. We've got two cases back to back, and it'd be nice to straighten this out and a published opinion.
So in your mind, then, did the appraisers make a determination that the damage that was claimed here was based on the storm versus normal wear and tear?
Well, yeah, that's subsumed within the notion that if you're assigned to set the amount of loss, then this is the loss you're dealing with. It's the loss that brings you there.
Is that a causation question or not?
You know, we're back to the old chicken and egg and sort of argument, but you cannot, as an arbitrator, decide what the amount of a loss is without identifying a loss. I don't know if you call that causation, but I think it's probably more, this is your assignment. This is the loss, determine the amount of loss. Okay? That's what you do. And so it comes to them prepackaged. They don't have to make a determination of what particular loss is. They just determine the amount of the loss.
In the prior case, you suggested the insurance company need to seek a DEC action, declaratory judgment action, before agreeing to arbitration or appraisal. Is that the same argument you can make here?
Yeah, although, you know, I talked with Mr. Deeker after that, and he sort of kicked me in the hiney for that. He says what often happens, and regularly happens, is the insured goes into court with a declaratory judgment action to say we have a dispute with the insurance company about the scope of the appraisal, how it's supposed to happen. So I think either way it would work, either the insured or the insurer would be going into court to get some guidance pre-appraisal process. I mean, the whole point of this appraisal process is like with any arbitration. You go in there, you get some knowledgeable people, they work together, agree, disagree. If they disagree, you bring in somebody else, an independent person, to try to resolve what's going on. And then it goes to the Superior Court. You get your arbitration award approved, or somebody comes in and says, woo, no, they've exceeded their powers. I mean, I've tried to do that, and it's never worked for me. I don't know why it gets to work for State Farm, or Foremost for that matter, whoever the other insurance company was.
What's wrong with the process that Judge Campbell laid out in Ocotillo?
And a good process it was.
I mean, I have a lot of respect for Judge Campbell. He's a very smart man.
He's immensely smart, and I like him a lot. And I can't remember what the process was, quite frankly, Your Honor. But what you could do is to try to get it lined up a little more in advance and get an agreement, you know, from the insurance company with the insurer. This is what we envision for the appraisal. Would you agree to these particular steps, instead of coming and saying, oh, this is how it's going to be, which is the way insurance companies like to send out letters to people. Oh, we're right, you're wrong, this is how it's going to be, and you don't have any say in it. But agreement would be nice.
If we disagree with you that in order to preserve, because I'm very sympathetic to the idea that you can't go in and then submit to this process and then relitigate things that you should have made clear weren't covered. But I'm also sympathetic to their argument that our contract and then that letter they sent made clear that we aren't agreeing that this process will resolve these issues. So what should they have done if I say, if you haven't sold me on the idea that the only way to do this is to do a DEC action in advance, what could they have done better here? And you could say, Judge, I can't think of anything other than a DEC action. But
Judge, I can't think of anything other than a declaratory judgment action other than...
It seems like that runs counter to the idea that this whole point is to avoid litigation if we can.
They made their bed. They get to sleep in it.
Right.
They're the ones that chose this appraisal process. You don't go through this as an insured. You're stuck with what they offered. So you go through the process in good faith. You pay for you pay part of it. They pay part of it. You're out of pocket for this process. You get a decent award. You go to the Superior Court, and everything will just line right up, and then you're done. And instead, they want to reinvent the wheel. They want to get and the judge in our case said a second bite of the apple after appraisal. That's exactly what they're trying to do.
Do the parties have any opportunity to participate during the appraisal process?
In
other words, let the appraisers maybe say, here's a draft, let us know what your objections to it are?
No. It's not like your typical arbitration where everybody comes into like Chris Scully used to do. You come into his nice office and everybody gets to say their part. Everybody, testifies, comments, and no, it's the appraisers doing their job. They might get statements from people, but as part of their investigation, was there really a hailstorm? Yeah, a hailstorm the size of a Volkswagen was falling out, whatever it might be. But no, it's not that thing at all. It's two professionals trying to reach an agreement based upon their examination of the records and the property, the evidence, the tiles, all that stuff. I think in here, the guy used a drone, which I thought was very creative. I'd have never thought of that. And take pictures of all these shattered tiles all over the roof. And I don't know how they come up with 1,000 tiles. It's like you go to Disneyland at Haunted Mansion, there's 999 ghosts. I don't know how they count all the damn ghosts. And surely it's more than...
They have an abacus.
Yeah, well, yeah. Anyway, the 1,000 tile thing
That
is...
was just a round number.
Yeah, I think it
piece
was
of
for...
the hypothetical.
Hypothetical, yeah.
Let me ask you a question, and I'm going to tell me if it's unfair and you don't want to answer, I don't want to create any issues for you. Is there a way that there could be a different result in this case than in the previous case? And I kind of asked your colleague that, because there is that one difference in the language on the insurance policies.
You mean that escape
One says
hatch?
causation specifically, and the other one says fact and coverage. So I'll tell you, I think that it's the same, that the result should be the same for either one. But you tell me if there's a way that we could differ in these two cases. Or you can say, I just don't want to
The
answer.
path of analysis might be slightly different. The end result should be the same.
Okay.
I mean, as you know from experience with dealing with me, my mind works in a very simple cogs and wheels and ruts. And they set this thing up so you would have this simple process. The arbitrators decide the amount of the loss, and they did that. And then when it blows up in their face, they don't like it anymore.
I mean, can the jury even award only 6 tiles worth of damage if it's not in the award?
Could you repeat the question, please?
Does the jury even have the option? So you have an award that at the very least has decided what the potential damages are.
Right.
Normally you would expect them to have sort of a menu, what to pick from.
Right.
Okay, you've now decided that there's causation, there's coverage.
Right.
Judge would instruct the jury, look at the arbitration award and decide which amounts on there flow from those two
Right.
findings. Here there's only one.
Right, one figure.
One figure.
Right.
So if the jury decides causation and coverage, which I don't know how they can't because State Farm has admitted there's at least some coverage and some
Right.
causation, at least with the existing award, they have to give $120,000, don't they?
If it goes to the fact finder in that fashion,
I'm not
yes.
saying that's a bad thing for you. That is a great thing for you.
More the merrier. And it's not because insureds or these particular insureds are greedy or anything. You pay a lot of money for your insurance, and you expect to get fair treatment when the roof literally falls in on you, and that didn't happen here.
Yeah, so unless we say the appraisers exceeded their authority by only including one figure, then if we confirm the award at least insofar as it decided potential damages, and then the jury finds causation and coverage, your client gets $120,000, right?
Yeah. Well, I don't know why in the world it would go to a jury though. I mean.
Or the fact finder.
Yeah. Well.
Assuming we have vacated the judgment.
Oh God.
And sent it back. I'm not saying we're going to do that.
Yes, Your Honor.
But if we were to do that, and the fact finder still says, okay, there's causation and coverage, the only option at that point is to award $120,000, right?
I don't know. I think you might be opening up the whole can of worms. You might be opening up for proof and testimony from the appraisers and then independent proof on top of that. I mean, the whole reason you go through this process and have a statute that says you get to confirm it and the other side you get to oppose it for specific grounds, the only one applying here being exceeding their powers, is to make sure this is simple and goes forward smoothly after an extensive appraisal process by professionals. But what you're opening up, I think you'd have to open up everything for the finder of fact to determine all of the facts and evaluate for themselves what the proper amount of the work could be. It could be really messy, really involved, and very, very expensive. I mean, you'd probably have to get an expert for State Farm and an expert for the insureds, and then you'd have the appraisers on top of everything else, charging you out.
That's one of the
arm and leg.
benefit to you to have to go hire experts and stuff.
Well, people love hiring experts. I don't know how you get around it. This is an expert-filled world.
What do you think about your opposing counsel's suggestion that we vacate or we confirm, or we affirm, excuse me, lots of terminology here. We affirm, or we could affirm the arbitration award, but we could do a limited remand for the appraisers to be more detailed in the numbers they provide in the award.
I don't see how you can statutorily do that, but I mean, you can, Wizard of Oz, you can do anything you want.
I mean, we direct.
Cole, I don't think you can do
things.
it under the statute, Your Honor.
Yeah, we direct lower courts to do things. It seems odd for us to direct an appraiser to do something.
It's very odd. So I don't think you could do it. I mean, it's creative, great points for that, but I don't think you can do it, Your Honor. I've got 40 seconds. May I cede my remaining time to the court, unless there's questions? Right. Thank you very much.
Thank you, Mr. Abney.
I'm not giving him the time, by the way.
No.
Okay.
We are going to rigorously enforce this 13 seconds.
I'm going to do what I can to make the most of it. Regarding the position of taking a deck action first, district courts have already ruled out that concept. That's the Ori decision, that's the Harvey decision, that's the Carbonneau decision. Those all said it's not appropriate for insurers to wait to appraise until this is resolved. That's the solution that Arrowhead found, was let's go through appraisal so that they get their timely benefit, they get their timely resolution. Thank you.
Thank you.
Counsel, thank you for your arguments. We will take this matter under advisement and issue our decision in due course. Stand adjourned.